Greetings of the day, everyone. I'm Palak Anand, and today I will be presenting a very important case under the Evidence Law BSA, the State of Uttar Pradesh versus Jyomin Upadhyay 1960. This case is highly relevant for understanding the concept of discovery of facts under the BSA 2023. As we know, evidence law governs what kind of material can be presented before courts. One key principle is that confessions made to police are generally inadmissible. However, this case deals with an important exception when information given by an accused leads to the discovery of a fact. So this case mainly examines the validity and scope of such discovery statements. So the background of the case is, in this case, the accused was suspected of committing murder. While in police custody, he gave certain information which led to the discovery of incriminating evidence. Now the major question raised was, can such information given while in police custody be used against the accused? The accused argued that this provision violates Article 14, that is equality before law. So the legal issue raised was, so the Supreme Court had to decide three main issues. First, whether Section 27 of the Evidence Act is constitutional. Second, whether it creates discrimination between accused persons. And third, whether such discovery statements are admissible in evidence. These questions are still relevant today under the BSA 2023. The relevant provisions, now coming to the legal provisions, Section 27 states that when a fact is discovered due to information given by an accused, only that specific part of the statement which led to discovery is admissible. For example, if the accused tells police where a weapon is hidden and the weapon is actually found there, then the part of the statement becomes admissible. Arguments. Now briefly looking at the arguments, the accused argued that Section 27 creates an unreasonable classification as persons in custody are treated differently. On the other hand, the state argued that this provision is necessary for effective investigation and helps courts find reliable evidence. So the judgment was, the Supreme Court upheld the validity of Section 27. It held that the provision does not violate Article 14. The court clarified that this is a special rule of evidence and only the portion of the statement directly linked to discovery is admissible. So the law strikes a balance between fairness and investigation. The principle established is that this case established a very important principle, which is information leading, although confessions to police are generally not admissible, information leading to discovery of a fact is admissible. However, courts must be careful to admit only the relevant portion and not the entire statement. Relevance under BSA 2023 is, under the Bhartiya Sakshya Adhiniyam 2023, similar principles have been retained. The law continues to protect accused from forced confessions, at the same time allow relevant, reliable evidence through discovery. Thus, this case remains highly relevant even today. At last, I would like to conclude that this case is a landmark in evidence law. It clearly explains the scope of discovery statements and ensures a balance between rights of the accused and needs of criminal investigation. Even today, courts rely on this principle while applying the BSA 2023. Thank you.